If you have searched for information about the Supreme Court's unanimous Social Security ruling and found 3 different websites giving you 3 different answers about what it actually means for your monthly benefit, that is because the legal language surrounding Supreme Court decisions is genuinely more complicated than most summaries make it sound. Headlines say things like drops benefits or affects all seniors without explaining the specific legal question the court decided, which program was involved, or whether the ruling changes anything for the average recipient who is already receiving Social Security. Today we are going to go through what a unanimous Supreme Court ruling on Social Security actually is, how the court's decisions interact with SSA benefit rules, and what, if anything, changes for recipients as a result, directly from the official SSA guidelines and publicly available court records in language that makes clear sense. I am Andrew, and I have spent time going through how Supreme Court rulings on Social Security are implemented by the SSA, what the agency's official response process looks like, and how those decisions filter down to affect individual benefit calculations. Everything here comes directly from SSA.gov, SupremeCourt.gov, and the SSA's published program policy updates. Before we get into this, if you find this kind of plain language explanation of Social Security and Medicare rules useful, subscribe and turn on notifications. Every week this channel covers one benefit topic in the same straightforward format, with no urgency and no alarm. Now let us get into exactly how Supreme Court decisions on Social Security work, what a unanimous ruling means in practice, and how the SSA translates a court decision into changes or non-changes for existing recipients. The most common misunderstanding about Supreme Court rulings on Social Security is that when the court issues a decision involving the Social Security program, it automatically and immediately changes the benefit amount or eligibility status of every recipient in the country. This misunderstanding is completely understandable because Supreme Court decisions are reported as major national events, and the language used in headlines, words like affects all 50 states or drops benefits, implies a sweeping, immediate, universal impact. But here's how it actually works. Supreme Court decisions involving Social Security typically resolve a specific legal question about how a particular rule or provision of the Social Security Act should be interpreted. The court does not set benefit amounts, administer the program, or directly change individual recipient accounts. Once the court issues a ruling, the Social Security Administration is responsible for reviewing its existing policies, determining which cases or categories of recipients are affected, and issuing updated program guidance that field offices and processing centers then apply going forward. The timeline between a court ruling and any visible change in individual benefits can range from several months to more than a year, depending on the scope of the decision and the SSA's implementation process. We are going to go through each part of this in detail so that by the end of this video, you have a complete and accurate picture of how this process actually works. To make this concrete, let me use an example. Consider someone like Walter. Walter is 69 years old, lives in Reno, Nevada, and spent his career as a municipal water systems engineer before retiring at 67. He has been receiving his Social Security retirement benefit for 2 years and receives $2,104 per month. After seeing a news headline about a unanimous Supreme Court ruling on Social Security, Walter believed his monthly benefit amount was going to be reduced. The headline used the phrase drops benefits and referenced all 50 states, which Walter interpreted as meaning that every Social Security recipient would receive less money starting the following month. Here is what was actually happening. The ruling Walter read about addressed a specific legal question regarding how the SSA calculates benefits for a narrow category of recipients, specifically those who had certain types of non-covered pension income that interacted with a provision called the windfall elimination provision. The court's unanimous decision clarified how the SSA must calculate the offset in those specific cases. Walter's benefit was not in that category. His earnings record consisted entirely of Social Security-covered employment, which meant the ruling had no effect on his payment whatsoever. Understanding what the court actually decided rather than what the headline implied would have answered his question immediately. This is not unusual. Supreme Court rulings on Social Security frequently apply to a specific subset of recipients, and the gap between a headline's description and the actual scope of the decision is one of the most common sources of confusion for people who receive benefits. How the Supreme Court's role in Social Security actually works. Let us start with the foundation. The Social Security program is established and governed by the Social Security Act, a federal statute originally passed in 1935 and amended many times since. According to SSA.gov, the SSA administers the program based on the rules set out in the Social Security Act and the regulations the agency publishes under that act. The Supreme Court's role in Social Security is to interpret the Social Security Act when a legal dispute about its meaning reaches the court through the federal appeals process. The court does not manage the program, set payment amounts, or make eligibility decisions for individual recipients. What it does is resolve legal questions about what the Act means when there is a genuine dispute about its interpretation. A unanimous 9-0 ruling, which is what the title of this video references, means all 9 justices agreed on the legal answer to the question before them. Unanimity signals that the legal question had a clear answer under the statute or the Constitution. It does not tell us how many recipients are affected, how large any benefit change might be, or how quickly the SSA will implement the decision. You might be wondering, if the court rules unanimously on something involving Social Security, does that mean the change is simple and quick to implement? The answer is not necessarily. Even a clear legal ruling can require the SSA to review thousands of existing cases. update its computer systems, retrain field office staff, and publish new program instructions before any recipient sees a change in their benefit. The implementation process is administrative, and it takes time regardless of how unanimous the legal decision was. What the windfall elimination provision is, and why it matters now that we understand the court's role. We can look at the specific area of Social Security law, where unanimous rulings have had the most direct impact on benefit calculations for a defined group of recipients. The windfall elimination provision, commonly called the WEP, is a rule under the Social Security Act that reduces the Social Security retirement or disability benefit for workers who also receive a pension from employment that was not covered by Social Security. According to SSA.gov, the WEP exists because the standard formula used to calculate Social Security benefits is designed to replace a higher percentage of income for lower-wage workers. Workers who spent part of their career in non-covered employment, such as certain state and local government jobs, or some foreign employment, can appear to the SSA's formula to have been lower-wage workers than they actually were, which would give them a proportionally higher Social Security benefit than the program intended. The WEP adjusts for this. This next part is where it gets more specific. Not every Social Security recipient is subject to the WEP. According to SSA program guidelines, the WEP applies only to recipients who receive a pension based on work not covered by Social Security and who also qualify for Social Security retirement or disability benefits based on their own earnings record. Recipients whose entire career was in Social Security covered employment, like Walter in our example, are not affected by the WEP at all. The maximum WEP reduction in 2026 is $587 per month. Most recipients subject to the WEP see a smaller reduction, because the reduction is calculated based on years of substantial Social Security covered earnings. This applies in most cases. Exception involves recipients who have 30 or more years of substantial earnings in Social Security covered employment. Those recipients are fully exempt from the WEP reduction even if they also receive a non-covered pension. In Walter's situation specifically, because his entire career was in Social Security covered municipal employment where Social Security taxes were withheld, the WEP does not apply to his benefit calculation. His $2,104 monthly payment is based entirely on the standard benefit formula and is unaffected by any ruling that addresses WEP calculation methodology, how the SSA implements a Supreme Court decision, and finally, this is the piece that ties everything together. When the Supreme Court issues a ruling that affects how the SSA must apply a provision of the Social Security Act, the agency follows a structured implementation process. According to the SSA's publicly available program policy update procedures, the agency first reviews the ruling and determines which categories of current and former beneficiaries may be affected. It then issues updated program instructions to field offices and processing centers. In cases where the ruling results in underpaid benefits for a group of recipients, the SSA conducts a review of affected cases and issues retroactive payments. You might be wondering, if a Supreme Court ruling means I was underpaid in the past, how far back does the correction go? The answer depends on the specific ruling and the SSA's implementation guidance. In most cases involving retroactive corrections, the SSA applies the correction from the date the legal error began affecting the recipient's benefit, subject to applicable statutes of limitation. The SSA will notify affected recipients by mail when a retroactive correction applies to their account. The maximum Social Security retirement benefit for someone who claimed at full retirement age in 2026 is $4,018 per month. The average benefit paid to all retired workers is approximately $1,976 per month. A Supreme Court ruling affecting the WEP would alter the benefit calculation only for the subset of recipients subject to WEP, which the SSA estimates at roughly 3 million people out of approximately 70 million total Social Security recipients. One thing worth understanding about how Supreme Court Social Security rulings connect to Medicare is that changes to a recipient's Social Security benefit amount can affect the income thresholds used to calculate Medicare Part B and Part 500 premium surcharges under the IRMAA rules. If a retroactive Social Security payment raises a recipient's reported income for a prior tax year above an IRMAA threshold, it could affect Medicare premium calculations in a subsequent year. This is not a concern for most recipients, just something worth knowing so you have the complete picture if you are in a category affected by a ruling. Before we finish, let me answer 3 questions that come up most often about Supreme Court rulings and Social Security benefits. Question 1. How do I know if a Supreme Court ruling on Social Security affects my specific benefit? Answer. The SSA will notify recipients whose benefits are directly affected by a ruling by mail. If you have not received a letter from the SSA about a specific ruling, your benefit is most likely not in the affected category. You can also log into your My Social Security account at SSA.gov to review your current benefit calculation and check for any pending adjustments, or call 1-800-772-1213 and ask a representative to confirm whether your account is in a category under review. Question 2. Can a Supreme Court ruling reduce my Social Security benefit if I am already receiving it? Answer. A ruling can change how a benefit is calculated going forward, but the SSA's process for implementing court decisions includes a review period. Recipients whose benefits may be affected are notified directly. Reductions resulting from a ruling are generally applied prospectively, and recipients retain appeal rights under the SSA's standard appeal procedures. Question 3. Does a unanimous Supreme Court decision go into effect faster than a split decision? Answer: no. The speed of implementation is determined by the SSA's administrative process, not by the vote count in the court's decision. A 9-0 ruling and a 5-4 ruling go through the same SSA implementation steps and are subject to the same administrative timelines. Everything we covered today applies generally, but your specific benefit situation may have details that change how a Supreme Court ruling applies to your account. The most reliable way to get your exact answer is SSA.gov, where your My Social Security account shows your current benefit calculation and any pending adjustments to your account. For questions about whether a specific ruling affects your benefit, call the SSA at 1-800-772-1213 and ask whether your account is in a category under review following any recent court decision. For Medicare premium questions related to a benefit change, Medicare.gov and 1-800-MEDICARE are the appropriate contacts. And if you need free in-person help understanding how a ruling applies to your situation, the Elder Care Locator at 1-800-677-1116 can connect you with a local benefits counselor. These resources are free, they are official, and they will give you answers specific to your situation, not general answers like this video does. One factual note before we finish. The SSA communicates by mail, not by phone calls, claiming a Supreme Court ruling has triggered a benefit review that requires you to verify personal information, not by text saying your payment has been adjusted due to a court decision, and not by emails asking you to submit documentation to receive a retroactive payment. If you receive communication like that, it is not from the SSA. You can verify any SSA communication by calling 1-800-772-1213 directly. I am curious, was there a specific part of how Supreme Court decisions interact with Social Security benefit rules that you found most unclear before watching this? Leave it in the comments. The most common questions become future videos. That is how a unanimous Supreme Court ruling on Social Security works, and what it actually means for recipients in all 50 states, explained as clearly as I can put it. If something is still unclear, the comment section is open and I read every question. If this was useful, share it with someone who read a headline about this ruling and was not sure what to make of it. I am Andrew. I will see you in the next one.